Joining me now, I have criminal defense attorneys Melanie Legrone and David A. Katz. David, I'd like to start with you first, if I could, please, because I understand you are a former prosecutor. Talk to us about the video that you just watched and the body cam video of when he went and found the victim in the vehicle.
Well, the video was very compelling. You know, it's like in the George Floyd case and all these other cases where you now have a video. When I was a federal prosecutor, we normally didn't have the luxury of being able to actually show, what had happened. But in these violent crime cases, just like in the Floyd case, I mean, you can believe your eyes. You can see it for yourself. So I think that, my view on this case is it's really a tragedy. This woman obviously felt very scorned, very angry. She admitted that she was the perpetrator, and she didn't really seem to have much of a plan, although she had a plan to premeditate it. She didn't seem to have a plan to cover it up or to get away with it. And I think part of it might have been her psychology that she wanted the world to know what she'd done. She wanted her husband and that woman to know that she was wronged in what she's done. And, a kind of, in her mind, maybe moral or ethical justice. But of course, it's totally legally wrong. And I think that although the defense has tried to portray her in a sympathetic way, and I think her defense attorney was effective, I think that this may go very badly for her when the jury comes back.
Still with me, criminal defense attorneys Melanie Legrone and David A. Katz. David, let me start with you if I could. All right, the police knock. We've got a good friend who lives in the neighborhood who is law enforcement. When he knocks on our door, the entire family knows it's him because the police knock is different than most neighbors knock. Police knock, nothing, nothing, nothing. Another police knock. Is there any way in closing argument the state could argue, listen, she heard the police knock and then she jumped in the shower, she hid evidence and then came back to the door after a little bit?
Well, Judge, they could very much argue that this was consciousness of guilt, that this was part of her overall pattern. As I said before, she didn't seem to have much of a plan really to get away with it. But having the police knock on your door and you know they're there after you, some things occurred to her in the moment, like maybe to wash some clothing, maybe to wash herself off, maybe to have an excuse while she was hiding stuff, why she wasn't answering the door. That may have all been a ruse, that she was taking a shower or had a reason to be in the bathroom. But the evidence, as I said before, just seems pretty overwhelming in her case regarding her plan, regarding her stalking or hunting the girlfriend over at the fast food store. And I think that the police conduct here, from what I've heard so far, I imagine there would have been some search warrant motions if there had not been proper searches or if they needed a warrant. But I defer to your police officer, but it sounds, based on my prosecutorial experience, like so far they haven't violated her rights. This seems like this was pretty good police work.
Oh, thank you. That's great insight about how their police work was when they didn't have a warrant at this point in time, as far as we know. After the break, we will talk about the state's attempt to prove Michelle Boat intended to murder Tracy Mondaba. That's next on Court TV, your front row seat to justice. Talk to us about no contact orders, because we know there was a no contact order in place when she was seen going onto the work property where the husband worked, and the no contact order was as to her husband.
Well, these have become very frequent, even more so than when I was a prosecutor, federal prosecutor here. But of course, they're very frequent. People get them very often in these kind of domestic dispute cases. The two of them had been separated some months before this incident. And as you said, the ex-wife, or the separated wife, kept this calendar of every day her husband was away, which also goes into the premeditation, plus the various implements that she had, kept, or what the prosecution's going to say exactly her premeditated purpose. So I think that when you add all of this together, it just ends up looking like a very bad case for her, and she might actually be convicted of premeditated murder with malice aforethought. Might actually happen in this case.
Yeah, and those no contact orders, there's a reason for them. They're the right thing to do, but I think sometimes people forget that it's only as good as the paper it's written on. So if you have an individual who chooses to violate it, then they're going to do that. Just quickly, David, was there anything else you noticed in that video in the last 30 seconds that we have?
Well, it would have to be zealously enforced, obviously, any kind of protection order, and that's the problem. You're right. Sometimes people don't take them seriously. sometimes some people kind of invite more contact. You know, we've always had these cases where they get the restraining order, and then the person who got the restraining order doesn't want to be restrained. They want to be in contact, and before you know it, it all starts up again. And then everyone's claiming that they violated the contact order, and the other person violated the contact order. But I think in general, this case is going to come to a conclusion pretty soon. And with all of these videotapes, it's amazing. It's like a fictional TV show, but it's real.
All right. And I mentioned before, David A. Katz, you're joining us now. I'd love to hear your thoughts on, first of all, the actual federal indictment and charges being brought.
Well, first, that was great reporting on breaking news that really wrapped up what happened. It happened just today. As a former federal prosecutor myself, I wish that we had had more of these federal civil rights indictments. You know, I was there in the Reagan administration, and had it been presented to me, I would have brought it forward. I would have indicted it. I would have taken it to the grand jury, but the FBI just did not develop those kinds of cases. You can imagine the Los Angeles Police Department and the sheriff certainly didn't investigate those kind of cases against their own misconduct and their own police brutality. And so those cases just were vanishingly rare in those days. Now, with the videotapes and the people going around with mobile devices, we have a lot more of that kind of evidence. And in the George Floyd case, for the 9.5 minutes, I thought it was compelling. In this particular situation, Judge, I wonder just a little bit if this is a bit of federal overkill. And I say that because all these 4 people are being handled in state court. They all face a very substantial amount of jail time. These are not going to be probation cases if these people are convicted in state court. And so I kind of don't see the tremendous need. You know, when you had the Rodney King cops judge, there was a tremendous need. They'd been acquitted after having a change of venue to a very pro-law enforcement part of California. And they were all acquitted, despite the videotape there of the 50-some blows that poor King sustained and that you could see. Here's some of the problems that I have, if I can take a bit more of your time about my thoughts on this just breaking indictment. First of all, I think it actually does give Chauvin an argument. Now, I speak as a criminal defense attorney now and trying to look at it from both sides and what will they argue. I think he'll say, I applied a chokehold or a neck restraint in that case. I was never charged with anything. Nobody told me I was under criminal investigation. Now I applied another chokehold. I applied the neck restraint, the knee to the neck with Floyd. Maybe I did it too long, but I did the same thing that I did 3 or 4 years before. Nobody charged me with that. Here I am. Now they're trying to make criminal charges out of both of them. This was my training. Now, of course, he'd have to have some witnesses to back that up. And he doesn't want to testify himself in the state case. And I think it's dubious that he would testify in his own defense in the federal case. As to the other defendants, they've certainly thrown a monkey wrench into the scheduling in state court. It's kind of hard to imagine how their state trials could go forward. It would seem like the federal trial would take precedence. And one more thing, because they now have, as your reporter pointed out, separate federal charges against Chauvin, which involve a separate incident 4 years before that these other 3 had nothing to do with. I would think that at the very least, there would be a severance in federal court. And if they want Chauvin to go first and they sever the other 3 and have them go later, they're looking at a trial very, very far down the road. And all 3 of them are out on bail. They're out on bail in state court, and they got bail this morning in federal court.
David, wow, you had so much wonderful information and thoughts on that. Thank you so much. You're going to stay with us. Julia Janae, we really appreciate your excellent reporting on this breaking news. Still with me, criminal defense attorney and former federal prosecutor David A. Katz. David, let me ask you this. That testimony in and of itself, I don't find is super compelling. I mean, they live there. They see she's in the car. One of them calls the police. The other one hears horns, doesn't want to get involved. Is it significant in your opinion?
Well, I don't think that this is going to deliver a verdict one way or the other on the question, you know, whether this should be manslaughter or whether this should be murder. But I think they want to paint the picture of what witnesses heard and saw. That statement, you know, he's not yours, he doesn't belong to you, shows, you know, pretty clearly from the prosecution point of view what her state of mind is. Excuse me. And while, of course, you know, people are going to listen and look at the jurors, the jurors are going to look at everybody in the courtroom. That's very, very common. And I agree with all of those comments that it's important how the defendant looks in the courtroom, the jurors, a lot of times they're not paying that much attention to the evidence sometimes, but they're always paying attention to the people in court, and especially the defendant's face and mannerisms. And it's extremely important. I tried a tax case once, and I asked the jury afterwards. I convicted the person. I was a prosecutor. So what'd you think of my great arguments? What'd you think of my great evidence? And the juror said to me, my God, here's a guy with $500 pair of shoes on, and he's not paying his taxes. So they noticed his shoes more than I did. They noticed the face. They noticed everything like that. And they're noticing everything that this woman does and looks in the court. And obviously, sympathy is going to be one of their big arguments. I mean, whatever the legal arguments are, they hope that the jurors have sympathy for her because she's a sympathetic, tragic, I think, angry and scorned figure. But she's certainly sympathetic on one level. I mean, her life did fall apart.
You make such a great point. Jurors notice everything. You're absolutely right. And in the picture that we were showing while you were explaining that, there was a picture of Nick Boat. Now, that's the husband who testified against his wife on the very first day. And the import is he was one of the last people to see Tracy Mandaba alive after she brought him lunch where he works. Let's listen to Nick Boat talking about the day of the murder.
I got up, Tracy and I had breakfast, and she took me to work, and we were there about 1:45 in the afternoon.
At some point later that afternoon, did you see Tracy Mandaba again?
Yes, she brought me supper.
Where did you eat your supper?
In the parking lot in the pickup.
Was it just you and Tracy?
Yes.
Was this a special occasion, or is this something that you would typically do?
It was typically what we did. She would come and bring me lunch.
Any particular reason?
So we could spend time together.
The significance to that, part of the significance, David, to me is his testimony. I found him very credible, very believable. He was just saying what happened, that it was typically what they did, that typically she went there and brought him lunch, which makes me wonder if part of the point of this witness's testimony is the wife knew that or had been stalking and had a plan. What are your thoughts?
Well, as you say, there was a restraining order in place. So she was supposed to stay away from him. And he was probably reciprocally supposed to stay away from her. He got separated from her. People have a right to get separated. We have divorce and we have separation in this country. I don't know. It just the whole situation just spun completely out of control. And in a perfect world, it would have been nice if they had made sure that she obeyed this restraining order. But, there's millions, literally millions of them issued across the country. And who has the resources to make sure they're all being observed all the time? And then when something like this happens, you think, my goodness, wouldn't it have been great if these people had stayed away from each other? Wouldn't it have been great if she'd been searched and found to have had, these dangerous implements on her? But she wasn't. And it went down the way it went down. And as I say, now it's sort of stranger than fiction, but it's real. It's a real, murder mystery, except that she admits that she did it. It's a real, what was in your mind at the time? But I just don't think, as well as her defense attorney is doing, I just don't think that she's going to arouse enough sympathy in the jury, because she kept this calendar. The 69 days also is the 69 days that she planned it. Seems to have gotten angrier and decided more and more that this was her man and that nobody else, despite the divorce laws and the separation laws and the restraining order, that no one else could have him. And you obviously cannot act on an impulse like that. You can't have a civilization if people act on that kind of vengeful impulse. And her defense is what was in her mind. And for her to explain what was in her mind, it might work. At the same time, you can look at her, just in the snippets that you've shown, you can look at her in court and you can see what was in her mind. You can see that this woman's life was really devastated, that she loved this man and she couldn't imagine life without him. And she spent 69 days trying to imagine life without him, and she just couldn't. And she lashed out in this way, maybe premeditated, getting the implements, stalking, but she lashed out in this way. So I guess, how much do you add to it? I hope they have some psychiatric testimony. Some psychiatric testimony, if you can get it in, is very effective. I had the murder of a postal carrier in federal court. It was a federal crime because it was a postal worker on her rounds. And the defense tried to put on mental evidence. It didn't work very well. We were ready for that. And we had great psychological evidence on our own side. But obviously, if you're trying to show, you can't use lay testimony. You can't have this sort of, kind of a lay diminished capacity. And the laws are very strict in the states and in federal court, but you can put on a mental defense, and your mental defense can diminish, right, murder into manslaughter.
Right, absolutely. And you know, a lot of people say to me, why would she kill somebody because of a man? Why not just divorce him, or why not accept, or why not get therapy? It's not the end of the world. But the reality is that may be a rational thought, but it doesn't explain, and you can't always explain the senseless crimes committed by criminals. All right,
Tell
David.
your friends to go. Tell your friends to go to the opera sometime. They'll see for hundreds of years that people do not act rationally in jealous situations.
Absolutely. I would agree with that completely. David, I know you're going to stay with us. Thank you for that. All right. Still with me, I also have criminal defense attorney and former federal prosecutor David A. Katz. David, let me ask you, if I could please, what do you think? Do you think the prior acts convictions would be admissible or not in this particular case?
Well, I think you put your finger on it, that they would have to show that they knew something about him, particularly that they knew him personally. Now, if they knew that he had a criminal record, that would be something, but it would have to be one of those three people. Now, they could know it from hearsay. That's not the issue, hearsay or proof that it's true. The point is, if they believed it to be true, even if they believed it from hearsay. But if they didn't know anything about him, they don't just get lucky because the fact that they wrongly chased somebody turned out to be a person who had a criminal record that they knew nothing about. I mean, this case has always looked like jogging while black. That looks like the only thing that he did wrong here was jog while black in their neighborhood. And these three white fellows who got charged didn't like it. Now, if they had a suspect who had broken in and the suspect looked something like him, that would be relevant from a different point of view, because they would say that the fellow who was running by, they didn't just accost him and chase him because he was a black young man, but they could say because he looked like the person who'd been suspected of burglaries. He was 6 foot and thin, and the person who had done the break-ins was reported as being 6 feet and thin. But I think that generally the judge is going to keep this out on the prosecution motion, going to find that it is not relevant evidence unless one of the defendants can say that they knew something. Let's say they had seen his criminal rap sheet, or they'd seen a story about him, and they knew that that was the person who had the criminal record, that was the person mentioned as having had some prior incident. The fact that it was 2 or 3 years ago, I don't think that's going to matter if they have that relationship that they knew about it. Because, you know, we let in criminal convictions that are 10 years old. In some situations, we let in criminal convictions that are even more than 10 years old, which I don't agree with. But as a criminal defense attorney, normally representing the defendant now, I have to live with the fact that most judges will let that in, even sometimes if it's been expunged or something like that.
All right. Thank you, David, for great insight. David A. Katz still with me. We only have a minute, but I have to ask, is it possible to try a case and get a conviction without a body?
Well, it's very much possible. And there have been quite a few celebrated cases and, of course, unsung cases. Murder cases are very hard for several reasons. One is because the victim of the assault is dead, right? It's not an assault case. So the person who actually was killed can't come forward and testify at all. If you find the body often provides evidence like DNA or something else that may implicate the alleged perpetrator, right? But in this case, it just seems like a total mystery. And again, they must have compiled some pretty compelling evidence from their point of view of why the husband is suspected of murdering his wife. But on the face of it, and I know the community seems to have this feeling, but you know, he's presumed not guilty. We haven't really heard the evidence. At least I haven't. And it sounds like it's going to be a very difficult case. You know, we all know from Perry Mason and stuff like that, how people go about proving murders, where it's a mystery whether it happened or not. You know, did he buy a large amount of life insurance? Was he seeing somebody else? You know, all those kinds of things. I'm sure that's what they think they've discovered.
I'm going to stop you there in the interest of time. Thank you so much for joining me today, David, and helping us break all this down. Next up, Michael Ayala.